Court does call the case of the People versus Jillian Sartori.
As well as for the people.
And Your Honor, show the time. Sartori. State your name, Jillian.
Jillian Sartori.
All right.
And we've
I have
the resolution. Thank you.
I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of retail fraud in the third degree, the 93-day offense. There is also a sentencing agreement between the prosecutor and defendant of HIDA and restitution of $152.16.
That's correct, Your Honor. And did the court get the agreement to hide them? Sorry, I missed it.
Yes, I said HIDA and restitution.
Thank you, Your Honor.
Right. Thank you. That's true, Your Honor. And the agreement is, it's extended HIDA, so it's necessary for.
The prosecutor.
Yes, thank you.
All right, very good. May I have her?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so state your name.
Jillian Sartori.
You can.
All right. I'll just need you to speak up a little bit if you would, okay? Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All
Your
right.
Honor.
Your Honor.
And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date, hang on 1 second, should have gotten this earlier. They put my complaint. Seriously? Hold on. Do you see the complaint in this one? I don't. No.
I think that's the second page right there.
You open the file without a complaint.
No, I got
Does the court need a copy?
it.
You're right, thank you. First, I get it. On the date of October 18, 2024, at the location of 3749 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, what did you do at the Target store that makes you think that you're guilty?
Could you repeat the last sentence?
What did you do at the Target store that makes you think that you're guilty?
I stole from Target.
Okay, you went into the store
Yes.
and you took some items?
Yes, Your Honor.
All right. Tried to walk out of the store without paying for them?
Yes, Your Honor.
The store was open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
And the property you took was property that was offered for sale by Target?
Yes, Your Honor.
All right.
This question matters more than people realize. The judge isn't asking what happened, he's asking for a legal admission. One clean sentence locks the plea in. No speech, no excuses, just enough facts to satisfy the law.
Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined in the Michigan court rules, the court would no longer be bound by any sentence evaluation or agreement. You understand that?
Yes, Your Honor.
You also would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor, the people are aware of an additional case that would technically be a bond violation for this case. We're not intending on pursuing it as a bond violation case. Want to make sure the record's clear on that.
All right. And
Thank you, Your
the
Honor.
court
And
had been apprised of
Yes.
that.
thank you.
All right. Any Any other thing?
No, Your Honor, thank you.
And has the court complied with the court ruling? Would it be proper to accept this defendant?
People are satisfied?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be September 24th, 2025. Are we doing that?
Pardon, Your Honor?
Yes.
9 a.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you, Your Honor. Conference room.
Court does call the case of the people versus Aline Wood.
Ashley Feltus for the people.
Morning, Tom Pietrowski on behalf of Ms. Wood, who's in court today. Standing to my right, ma'am, would you introduce yourself, please?
Hello, my name is Aileen Jane Wood.
Thank you. All right, what are we doing?
Yeah, I believe we're at a point where we're just asking the court to set a final settlement conference, and I think those dates are sometime in October.
Jury final settlement conference, we set October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025.
And just like that, next case. This is the rhythm of docket day. Pleas, adjournments, scheduling. Most of these cases don't end today. They just move one step closer to resolution or trial.
8:30, both of those proceedings are in person.
Yeah,
Thank you.
may I ask the court a question?
Yeah, I don't know if I'll, go ahead.
For scheduling purposes, we would be intending, and I let Ms. Lonnie, I'm sorry, let the prosecutor know that I haven't changed my name, believe it or not. That our intention would be to waive. I don't know if the court needs to know that now or.
You want to proceed to this and then make a determination that you may waive.
That's correct, Your
All
Honor.
right.
We
Yeah.
would bench after counsel.
Right,
All right, very good.
sounds good. Thank you, sir.
Thank you. Bond will continue. Court does call the case of the people versus Joseph German.
Your Honor.
Ashley Feltus for the people.
Good morning, Your Honor. May it please this honorable court. My name is Jay Dallow, P number 72879. Appearing on behalf and with my client, Mr. Joseph German, who stands to my right. Sir, can you please state your name for the record?
Joseph German.
Your Honor, today's date and time set for a pretrial on this matter. I've had the opportunity and the pleasure to speak with Sister Counsel. Ms. Feltus to my
That's
left.
funny. Pleasure. Go ahead.
But it's true.
Yeah, okay, whatever. You're still young. Go ahead.
Thank you, Your Honor. We're going to be submitting, we've submitted a deviation request. We've updated and had it forwarded to Sister Counsel. I think both parties are just asking for 2 weeks if we can return. If Zoom, if it would please the court to appear via Zoom. As much as I love Ann Arbor and I went to school here, I did
Sorry
drive.
to hear that.
Okay. You're not a Buckeye, are you? Okay.
Alan, take it.
Well, you are wearing red.
Am I a Buckeye?
I did.
To Michigan. I grew up here, but he went to Michigan and he asked me if I'm a Buckeye.
Yeah, well, based on
You
your,
want to know?
I did drive about. I live in Sterling.
He's just not acquitting himself well. So any request you make, no.
Good. So any request?
I am a
No.
very proud Maryland Terrapin.
Oh, that's cool.
I know.
So any request I say, ask would be no. So we would like to appear in person. So.
No.
Yeah.
Okay.
Perfect.
Very good.
You're right. Yeah. Thank you, Judge.
What's my next date? 17. Does that work for you?
That's perfect, Your Honor. Thank you.
I'll adjourn the matter to September 17th, 2025, 9 a.m. Bond will continue, and you'll have to submit the form and then consider the Zoom request.
Oh, yes, Your Honor.
All right?
Yes. Thank you. Have a great day.
You do the same. Court does call the case of the people versus Eric. Is it Kenise or Ken?
Casey.
Casey.
Ashley Feltus for the people.
Good morning, I'm Robert J. Coleman. Mr. Casey?
Your name, sir?
Eric James Casey.
All right, thank you.
Your Honor, Mr. Kellerwald presented some information to me yesterday. I need to discuss with Detective Yeager about this case, so I'd request an adjournment for that purpose.
Will the 17th work?
That's fine, Your Honor. Thank you so much.
This is September 17th. That's a Wednesday.
Yeah.
Okay.
Adjourn the matter September 17th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Jason Eckley. Eckley.
People?
Good morning, Your Honor.
Good morning. Go ahead, counsel. Place your appearance on the record.
Thank you. Good morning again, Your Honor. Robert Goldman, P81222, appearing on behalf of defendant Jason Eckel, present by way of Zoom this morning. We thank the court for its accommodations to appear by way of Zoom. Mr. Eckel, could you please state your full name for the record?
Jason Eckel.
And what are we doing today?
Thank you, Your Honor. This is a date and time set for a first pretrial in this matter. I did receive discovery from the prosecutor's office. I do need to follow up regarding one piece of discovery that I'd like to further inquire into. However, in the interest of judicial efficiency and economy, I would ask if the court could schedule the matter for a final settlement conference during which, in the interim period, I can address the request or inquiry with the prosecutor's office. And otherwise prepare to try to resolve, but if not, we'll be prepared to proceed with trial in the matter.
Your Honor, if the court wouldn't mind, could we just adjourn the pretrial rather than setting it before we have all the discovery over? I want to make sure defense counsel has everything he needs. We don't have to delay this case at final settlement if there should be something missed.
If you're looking for additional information and discussion, I'll just adjourn the pretrial out. I'll adjourn the pretrial to September 17th, 2025, 9 a.m.
And Your Honor, I'm getting into the Zoom in just a moment. I'll put my contact information in the chat so defense counsel can email me directly.
All right, very good.
Thank you.
And I'll be right there.
All right, thank you. Bond will continue with its conditions. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus William Dapkowski.
People?
Good morning, Your Honor. Paul Pavelski for Mr. Dapkowski, who is in person.
Yes. Your name, sir?
William Dapkowski.
All right, very good. What are we doing?
Your Honor, Mr. Dapkowski, the last pretrial was adjourned for Mr. Dapkowski to be screened for participation in the sobriety court program. And I did receive an email from Mr. Heaton that he had been approved and accepted for participation in the program. So we would be prepared today to tender a plea to the charge of OWI second. And Mr. Heaton asked for a sentencing date of 9/25 at 9:30 a.m. for him to be accepted into the program if the court will go along with that.
Well, I have to, how are we doing that? Are they sentencing the entire sentence or?
Sobriety court is not a free pass. It's structured, monitored, and unforgiving. One slip, alcohol use, missed check-in, failed test, and the original jail sentence slaps right back into place. It's accountability with a stopwatch.
The transfer of that into 14A. Do we have clarification on that?
We do not have clarification. I do know that we received an email from Mr. Heaton that indicated that they could see him the day after our next sentencing docket.
So I would we're just gonna do it that way.
Yeah.
All right. So what will happen, counsel, is he's got the 25th date, but I will be setting my sentencing date because it's a little bit weird, but I will be assessing at that time fines and costs and then referring him to the court. Seems an odd way to do it since we're all one court, but we haven't worked out all of the details. All right.
Thank you, Judge. That's fine.
All right. Very good. Sir, if you could please raise your right hand to be sworn.
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, self.
Yes.
State your name.
William Dapkowski.
And he's going to plead to operating while intoxicated second offense. Is that correct?
Yes.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
And understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
I do also have to advise you that, well, actually, you'll be sentenced by me, but you'll also be appearing before Judge Freshour. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. Did you sign an advice of rights form, sir?
Not at this time, but I can do that.
He may have done one. He may have done one previously, Your Honor. I'm not sure, but I did review the form with him.
So do you recall reviewing an advice of rights form with your attorney?
Yes, Your Honor.
All right. Do you have any questions? I've handed you a copy. Do you have any questions regarding any of those rights?
Not at this time.
All right. Please look at paragraph 5. You'll see a copy on the podium highlighting paragraph 5. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been, well, has anybody promised you anything to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
That is correct, Your Honor.
March 12, 2025, at the location of Laura Road near Textile Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, I did.
What did you have and how much?
At least a pint and many beers. So I was
Pint of,
vodka.
okay. Were you stopped by the police or was there an accident?
I was stopped by the police for speeding.
For speeding?
Yes.
All right. You're not disputing the right of the police to stop you, are you?
No, Your Honor.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital or to the station?
I was taken to the police station.
All right.
And Your Honor, I have the results of the,
Was that an intoxicator?
it was intoxilizer, yes, Your Honor.
Okay. And were the results of that 0.137, sir?
Yes, Your Honor.
All right. Do you have any reason to dispute those results?
No, Your Honor.
Prior to that, on July 14th, 2022, City of Adrian, were you convicted of operating while visibly impaired?
Yes, Your Honor.
All right. Sir, I do have to advise you that if you commit misconduct as defined in the Michigan court rule between the time of my acceptance of your plea and the time of sentencing, that any agreement or evaluation, the court would no longer be bound by. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Your
No,
Honor,
Your
only the entry into sobriety court that we've
The
already.
entry into, right.
Nothing else.
Nothing else, counsel?
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
All right. Court will accept the defendant's plea of guilty to this charge. Has he already been assessed at? He's done an assessment already. Is that correct?
Yes, he has with probation, and Mr. Heaton has sent an email accepting him into the program.
Okay, so here's what I'm going to do. I'll refer you. I'm not going to refer you to Von Swartz, but I'll refer you for an assessment, which you've already ideally completed. I'll set sentencing for this part of the case for September 24th, 2000. Is that right?
Yes.
September 24th, 2025, 9 a.m., or as your invite indicates. And then you'll have the next appearance on the 25th.
Okay.
Okay, we'll do it that way. Bond with its conditions will continue. Thank you.
Thank you.
Court does call the case, People versus Damian Poupette.
House bill is for the people.
Good morning, Your Honor. Excuse me. May it please the court, Ezra Golden on behalf of Mr. Poupette.
My understanding is he's going to enter a plea to the charge of operating with a high BAC and proceed to immediate sentencing with the 15th District Court sobriety.
There should be a plea form, Your Honor, for operating while visibly impaired. Second offense.
That's what I was going to say.
We do.
So so that is what we'd like to do today, Your Honor. Please go ahead and count 2 of offering, while physically impaired second offense, to go into sobriety court. This is count 1. I do believe that he has been screened and assessed and accepted already to 15, if I recall correctly. Based on this.
Sentence agreement that he's to enter that sobriety court.
Yes,
He's
Your
been accepted into that program.
Yes, sir.
That's the court's full understanding of the agreement.
Mine as well, Your Honor.
I will check the sentencing. He understands that I'm going to pose the first part of his sentence. Counsel.
Part here and part there. You know, Your Honor, every district judge does this a little differently, but yes, I understand.
I do it right, though.
Okay,
but
yes.
All right, that I will be doing that. So what I've done is he understands the sentencing judge waiver in this case.
Exactly.
Because he'll have the other part. We'll just cover that. All right, may I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Damian Pupa.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired second offense. Is that
Yes,
correct?
Your
All right. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Not at this time.
Look at paragraph 5, you'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're indeed guilty of this offense?
Yes, Your Honor.
February 22nd, 2025, at the location of I-94 near Ellsworth at Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
Some whiskey, 3 to 4 glasses.
All right. Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
They said I was driving under the speed limit.
Okay, so you're driving too slow for the highway?
Yes.
All right. Are you disputing the right of the police to stop you in this case?
No, Your Honor.
All right. Were you ultimately arrested?
Yes, I was.
And were you taken to the police station or hospital?
I was taken to a hospital.
All right. Was there a blood draw?
Yes.
Were the results of that blood draw 0.192?
Yes, Your Honor.
Do you have any reason to dispute those results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Had you previously been convicted of operating while impaired on or about September 24th, 2024 in the 35th District Court?
Yes, Your Honor.
All right. Sir, if I do accept your plea in this case, and you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, any sentence agreement, the court would no longer be bound by, and you could not withdraw your plea. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Just a sobriety court, Your Honor, nothing else. Thank you.
Nothing else, Your Honor.
All right. Have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2, the operating while visibly impaired second offense.
So thank you for that, Your Honor. I would ask the court to consider immediate sentencing. I believe it's already been screened.
Yes, he has, in this case. Anything either of you like to say before I do impose sentence?
Sure.
I'll just highlight to the court, Your Honor.
Okay.
Mr. Pupet is, first, has not had a drink since this incident. He is on an alcohol tether, so that will support that. He is full-time employed for Progressive Insurance. He's a fraud investigator. This is something he can do remotely from home, and he's been working full-time at that. It is his second offense. He's looking forward to the opportunities offered by the sobriety court and has a positive attitude about that. So I don't think the court will see him back for any violations.
Anything you want to say, sir?
Not so right now. I just want to say I don't want to be here, and I'll do everything I can to not come back.
You know, sometimes I feel that way. All right. It's the sentence of the court. Place you on 24 months probation, term with supervision through the 15th District Court, Sobriety Court. You're to pay $1,255 fines and court costs. That's payable to 14A1. $100 prosecution recovery cost. That's also payable to this court. And $100 police agency recovery cost payable to this court. When can you pay that, sir?
If you need 60 days, then whatever,
60 days. 60 days.
Is that
Do you have anything today that you can pay on this?
Is it a date?
today?
Today,
Can you pay any of it today is the question.
yes, I can pay some today.
Okay, how much can you pay today?
I can pay $500 today.
Thank you. $500 today. And then I'll indicate that the balance would be due by November 1st, 2025. Probation oversight fees will be set and paid to the 15th District Court. You're to comply with all terms and conditions of the 15th District Court Sobriety Court. I'll order 365 days in jail. Credit 1, the balance is suspended. All right.
One question, Your Honor. He has a tether. So he has a tether from his bond. I'm wondering if that's something
that will continue until such time as the 15th District Court makes it.
Or does it remove?
And that would be the request of the people as well, Your Honor, that it continue.
All right.
Okay.
Okay. Thank you. Court calls the case of the People versus Jennifer Carlara.
That's called the people.
Good morning, Your Honor. Marissa Voiles, P86438 on behalf of Ms. Galara.
Morning,
Good morning. Your name?
Jennifer Galara.
Thank you. All right. What are we doing on this case?
Your Honor, we would be sorry, go ahead.
Go ahead.
We'd be requesting an adjournment on this. We have received discovery. She does have a substance abuse evaluation scheduled, I believe, within the next couple weeks here, as well as a hardship case scheduled for October 1st. We would be requesting an adjournment.
Your Honor, is the court received a bond violation?
I have. And counsel, are you aware of the bond violation?
I am aware of it.
All right. Would you like to address that?
I do believe she has a court date scheduled on it within the next couple weeks as well. It is for driving without a license. There are some underlying issues regarding the status of her license. So if we could adjourn the bond violation to the next pretrial, I think that would be best.
Anything from the people on the bond violation?
It's concerning, of course, to the people that she was driving, but most concerning to me was the fireball in the back.
Yes.
So those are sort of the things that I would put forward to the court. I don't know if there would be a resolution necessarily like that. Where do we go from here, right? Like she didn't have her 625G and she had fireball. That's very concerning when someone's on bond for an OWI. I think, let me double check the notes. She had gotten a sober link because she was found to be in possession of alcohol. And I understand that she was saying she didn't know it was in the car. I am going to request that the court consider putting her on a scram tether. This is sort of a red flag to me.
Well, there are a couple of things. I guess I'm a bit concerned about why did she have her 625G permit or no?
She did initially, and then she only later received notice of the implied consent refusal, which she also did refuse. She just had trouble blowing. So she did have the permit and then only received that later. So, I mean, there were kind of some issues as to why there was the implied consent violation, and we are fighting that in circuit court right now.
Yeah, but she did know at the time that she didn't have a 625G permit. Did she not? Counsel?
That I don't know.
Part of the problem that I have here, counsel, is that she's driving. She's not supposed to be driving. And then there is Fireball whiskey in the back of her vehicle. And she's not to be in possession or consumption of any alcohol.
I do understand that, Your Honor, and to my knowledge, she has been sober since the offense, doing everything she can. So I don't believe she had any knowledge of that fireball being present. As
What's
we
the
have gone over
monetary
her bond conditions with her, and she is very aware.
25. Okay, well, counsel, if you want to get down here so we can address this later, but at this time, I'm going to take her into custody. Your bond on the warrant that I issued is set at $25,000 cash surety. So she can post, or you can come down and I can have her brought back out. But at this time, I'm going to take her in.
Can she post a cash bond today?
Pardon?
Can she post a cash bond?
If she has it, certainly she could post a cash bond.
Okay.
I mean, I'll allow a 10% on it, so that she doesn't have to go through a surety if that would assist on that. But that would be $25,000. I'll give a 10% privilege on that.
Okay.
All right. What were we going to do with the case itself?
The case itself, like I said, we received discovery. I think we have some ongoing negotiations regarding an offer, and she does have a substance abuse evaluation scheduled, I believe, September 10th.
So what I will do is I'll adjourn her case to September 17th, 2025.
This is the moment everything changes. One decision, one violation, and freedom turns into handcuffs instantly. Let me ask you this. Was this about punishment or public safety? Drop your take in the comments.
9 a.m. At this time, the defendant is remanded. Her bond will be set at $25,000, 10%.
Will the court also order the scram?
Not at this time.
Okay, thank you.
Thank you. Court does call the case of the people versus Justin Kitari.
People.
Good morning, Your Honor. Oscar Rodriguez, on behalf of Mr. Katarai, who is present, and speak your name, please.
Justin Katari.
All right. What are we doing?
Your Honor, I have not been able to with the prosecutor, but I do have a request to change the bond conditions that we'd like to make.
Okay. Well, first of all, what are we doing on the case itself?
Your Honor, I haven't heard any offers. Again, prosecutor and I have not been able to chat, but that's where we stand there. Obviously, if we have no resolution, this case needs to move forward towards trial. But I'm not sure if there are going to be any offers.
Did you want an adjournment of the pretrial? You want me to set it on the final settlement conference?
I think we can get an offer here, Your Honor.
All right. I'll adjourn this out so you guys can talk. I'll adjourn this to September 17th, 2025, 9 a.m. Yes, Esteban.
Your Honor, we have been on the Scram tether for now about a month and a half, and our request is to, in terms of saving money, to be put on the breathalyzer instead. the testing will still continue all the time. He has had no violations. He has his 30-day chip from AA. And so that's essentially the request, if we can go to the daily monitoring breathalyzer instead.
I'm going to deny that request. I don't need a response from the people. The basis for which he's on the scram tether is that his alleged blood alcohol was a 0.234. He has a prior driving while alcohol related offense, and there was a crash in this case. So I'm not changing that bond
Thank
condition.
you, Your Honor.
So request to change that bond condition is denied.
Thank you, Your
We'll
Honor.
see you in a couple of weeks then. Thank you.
Thank you.
Court does call the case of the People versus Eric Hopkins.
Josh Feltus for the people.
An arraignment. Just an arraignment.
Good morning, Your Honor. Wonderful to see you. Robert Ellman with and on behalf of Mr. Hopkins. Mr. Hopkins, can you state your name for the record? Eric Hopkins. Thank you.
I don't have anything marked in this one. It is an arraignment. All right. As to the arraignment portion.
Your Honor, we would stand mute and waive formal reading.
Defendant having waived formal reading standing mute, court will enter a not guilty plea to this charge. All right. And what are we going to do in this case?
Your Honor, I've been having wonderful, fruitful conversations with Mrs. Feltus, and I'm hoping that we will soon be able to reach a resolution, but we need a little more time to figure that out. And so I would ask for an adjournment to your next pretrial date.
We'll adjourn the pretrial in this matter to September 17th, 2025, 9 a.m. or as your invite indicate, I'll set the defendant's bond in this case as a $5,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons. There is to be no alcohol, no use or possession of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
I'm also going to order that you are not to enter any Home Depot in the state of Michigan. You understand that?
Yes, Your Honor.
All right. Anything further?
No, Your Honor.
Thank you. Court calls the cases of the People versus Rick Artuso.
Josh Feltus for the people.
Assistant Public
One of them, not all of them.
Assistant Public Defender Natalie Pate with and on behalf of Rick Artuso in the cases ending 1656 and 1657.
And good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso as to the remaining matter.
Your name, sir?
Rick Artuso.
Okay, what are we doing?
Your Honor, there is a resolution as to my two cases. There should be a plea form in the file as well as a signed advice of rights form.
I see. Okay, I get it. Okay. And then what about your case?
Your Honor, Ms. Feltus has got that right today. I'm working on it here.
Yeah,
I'm a little
me
slow.
too.
I'm a little slow sometimes, Your Honor. But she extended an offer to me. I do need to discuss with Mr. Artuso. So on my matter, I'm going to ask for an adjournment, Your Honor.
That's on 217.
Correct.
I'll adjourn that matter to September 17th, 2025, 9 a.m. is bond. In that case, we'll continue.
Thank you very much, Your Honor.
All right. And on the other matters, Mr. Artuso,
Yes.
can you raise your right hand, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
All right. State your name again for the record.
Rick Artuso.
All right. It's this court's understanding, sir, that you are going to be pleading guilty to the charge of no insurance.
Yes.
Is that correct?
Yes.
That is a misdemeanor punishable by a fine between not less than $200, not more than $500 plus cost. Do you understand that, sir?
Yes.
I don't think, and I think it's up to 1 year. Is that the one?
Correct, Your Honor.
And up to 1 year incarceration. You understand that, sir?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct, sir?
Yes.
Any question regarding any of those rights?
No.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
Not at the moment.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense, sir?
Yes.
On the date of December 19, 2024, at the location of Hillside Road near Ellsworth, in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
And at the time you were operating that motor vehicle, did you not have insurance or security regarding that vehicle?
No, I did not.
Okay, and you knew that to be the case, sir?
Yeah.
Okay. Sir, if I accept your plea in this matter, between the time of sentencing, the acceptance of the plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you could not withdraw your plea, and any evaluation by the court or recommendation by the court would no longer be bound by. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor. I don't know if it was just stated on the record, but just what was stated in the plea form, that case then 1656 would be dismissed.
Yeah,
But other than that, no, Your Honor.
all right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
We're satisfied.
Yes, Your Honor.
All right, court will accept in case ending in 1657. Court will accept the defendant's plea of guilty to this charge, and the other matter is dismissed. All right. And does he currently have insurance?
No, I don't have that. I don't have that vehicle no more.
I also understand the defendant has at least one pending matter, maybe more than one pending matter in circuit court. So there's sort of other things happening.
So he's going to be under the jurisdiction of another court.
That is correct, Your Honor.
All right. Any objection to the court proceeding with immediate sentence?
No, Your Honor.
No, Your Honor.
All right, sir, is there anything you want to tell me before I impose sentence?
No.
All right. Fines and costs of $300. When can you pay that?
I need at least a month.
All right. What I'll do is I'll make it payable by October 31st. Will that work for you?
Yeah.
Okay, pay it by October 31st, 2025, and I will suspend 365 days in jail.
Okay.
All right. Thank you.
Thank you, Your Honor. Mr. Artuso.
If I didn't say so, the other matter is dismissed.
Thanks. Thank you, Your Honor.
Court does call the case People versus Robert Stevens.
I should felt this with you.
Yes, hi, Your Honor.
Oh.
Hi.
And I think Ms. Weidling was just pointing out this was Mr. Gaddy's case as a private attorney. Mr. Gaddy now, I know the court knows for the record, is employed by the Public Defender's Office. So this person may need a new assigned attorney. Because this is from 2016.
I thought that we had wrapped this all up the last time I saw you. I didn't I wasn't aware that there was another meeting.
What do you mean?
I saw you at the end of what was it? Probably July. And we had I had pled to the other cases that we had and kind of
Well,
just
let's do
wrapped
this. Who was representing you when you appeared before me?
I didn't have an attorney there. It was probation who appeared.
Okay. I adjourn this to today's date. Do you want to be represented by an attorney on this, sir?
No, I think that this is such an old case, and last time we talked, I had explained how I live in Massachusetts now.
No, I recall all of that, but to try to get this resolved, do you want to be represented by an attorney? Because Mr. Gaddy is actually listed as the attorney on this case.
Oh, do I need one, or are we? I'm okay with just pleading, and or is that not an option this time?
It is an option. I'm not sure that it would be the most prudent or wise move, but I can't advise you what to do. So I'll ask you again, do you want to be represented by an attorney?
Sure. Yes.
I'll take that as a yes. This is a public defender.
Assistant Public Defender Natalie Pate with and on behalf of Robert Stevens. Your Honor, I would request an adjourned pretrial date, please.
All right. So this being a public defender case, I'm going to adjourn this out to September 17th, 2025, 2 weeks from today. This is a 2016 case, Ms. Pate.
Thank you, Your Honor.
So I'll adjourn it to that date, 9 a.m. Let's see if we can get this resolved.
And Your Honor, if I may speak directly to Robert Stevens, if you could call the public defender's office and give the best phone number for you.
Okay. Yep.
Right.
And who should I ask for again? I'm sorry.
You can just say, I need to give my phone number to Natalie, but the number to call would be 734 222 6970.
Okay. Thank you. I apologize.
All right.
You tell them you were just in front of Judge Simpson and you need to give Natalie your phone number. They'll put you in the right spot.
Okay. Thank you.
Thank you. Thank you, Your Honor.
Thank you. Court does call the case. People versus Jeffrey Ostermiller.
National Public for the People. Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Ostermiller. Mr. Ostermiller, excuse me, please state your name for the record.
Jeffrey Ostermiller.
Thank you.
Your Honor, I did not have contact with Mr. Ostermiller prior to today. I'm asking for an adjournment of the pretrial hearing, please.
I will adjourn this to September 17th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Christopher Banks.
People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Banks, who is present via Zoom. I believe he's trying to unmute him, Your Honor, in front of the Spartan flag.
He's in front of the Spartan flag. I don't want to hear from him anyway. See, this is what I'm talking about. How long does it take a Spartan to unmute? Oh, no. State your name, sir.
Christopher Banks.
All right.
Thank you, Your Honor. I have discussed this matter with my client, and then I have talked to the people. There is some media reference in the police report that our office does not yet have. So I'm requesting what I believe would probably be one last adjournment to get that media or confirmation that maybe it doesn't exist before setting it.
All right. I'll adjourn this matter September 17th, 2025, 9 a.m. And I suppose he'll be at a different location with a different flag in the background.
Yes, sir.
I'm just saying, no, you do you. All right?
Get a Buckeye.
Yeah, do that one.
Thank you, Mr. Banks.
Thank you, sir. Court does call the case. People versus Grace Bonilla.
National Public for the People.
How to attorney's leave.
These are all show cause.
No. She has all the remaining ones, only zeros
1005.
That's the only one that's on. So Nia? Oh, I got you. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give it 10% privilege on that.
Thank you, Your Honor.
That warrant will issue immediately. She had the other. Court does call the case People versus Daniel Bowe.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Bowe. Mr. Bowe, please state your name for the record.
Daniel Robert Bowe.
What are we doing?
Your Honor, you should have a plea form in your file.
I do. Plea form indicates that he's going to plead no contest, yes, to the charge of retail fraud, third degree, the 93-day offense. Upon a successful plea to that charge count, one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor. Yes, Your Honor.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record, please.
Daniel Robert Bowe.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would be the amount of the fine. You understand that?
Correct.
Or
Your
the
Honor.
amount of the maximum fine. All right.
Correct.
Do you understand what a no contest plea is?
Yes.
All right. Two things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Correct, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Correct.
Basis for the no contest plea?
Potential civil liability, Your Honor.
All right. Sir, to that charge, how do you plead?
Guilty.
Really?
No contest. I'm sorry.
Thank you. You understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Correct.
Any questions regarding any of those rights?
No, sir.
You understand that you're giving up the rights contained in paragraph 5 as well as all the rights contained on that form?
Correct, Your Honor.
You understand you're giving up your right to appeal of right?
Correct.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Correct.
and of your own free will?
Yes, sir.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-11486. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could accept the defendant's, could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of your sentencing, you commit misconduct as defined by the Michigan court rules. Any sentence evaluation recommendation, the court would no longer be bound by, and you would not be able to withdraw your plea. You understand that, sir?
Correct, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
All right. And have I complied with the court rule?
People are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendants referred to probation for pre-sentence investigation and report. Do I have intake here?
You do.
All right. Sentencing in this matter will be September 24th, 2025, 9 a.m. All right, bond will continue. Sir, I'll need you to wait online. We're going to put you into a breakout room with our probation department so we can get that process started. Okay, sir?
Okay, thank you, Your Honor.
All right, thank you. Court does call the case of the people versus Wesley Brand.
Ashley Feltus for the people.
Yeah. Your name?
Wesley Brand.
All right. This is an arraignment. Sir, you are before the court on a complaint that alleges that on or about June 2nd, 2025, at the location of 2201 Hogback Road, Effingham, Washington County Jail, that you did commit the offense of assault and or assault and battery upon an Alton Ford. You understand the nature of that charge, sir?
I do.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that, sir?
I do.
All right. First question I have for you is, do you want to be represented by an attorney?
I do.
Okay. Sounds like he's at a wedding. All right, this is a public defender case.
Assistant Public Defender Natalie Pitts, on behalf of Mr. Brand, we would waive any further reading of the complaint, stand mute, and ask for an adjourned pretrial date, please.
Defendant, every way from a reading standing mute, court will enter not guilty plea. Pretrial in this matter will be adjourned to September 17th, 2025, 9 a.m. Where your invite indicates. As to bond in this case, I'll set his bond at a $5,000 personal recognizance bond. Sir, I'm going to order standard conditions, including no assaultive behavior or possession of any weapons. You understand that?
Yes.
I'm also going to indicate that there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. Do you understand that, sir?
Yes.
I'm also going to indicate that you are not to have any contact with Alton Ford. Do you understand that?
Yes.
Anything else?
No, Your Honor, thank you.
No? Thank you, sir.
Thank you, Your Honor.
Court does call the case of the people versus Abduram Banda.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Banda. Mr. Banda, please state the record. Your Honor, we are here for a pretrial. I guess our request is to adjourn the pretrial, which is kind of connected to the bond violation.
Yes.
The bond violation report alleges that Mr. Banda had positive alcohol blows. I did speak with him and advise him he had a right to a hearing. He does not want a hearing and he wants to admit to the violation.
Is that correct, sir?
Regarding the pretrial, the reason for the adjournment is Ms. Feltus and I did confer about this case. We are going to request that Mr. Banda be released to treatment, inpatient treatment, given the alcohol use in the underlying case in these and this bond violation.
I will sign an order releasing the treatment if I'm presented with one, so that's not a problem.
And I will get that into the court.
All right. And then you just need an adjournment of this date?
Yes.
Adjourn this to September 17th, 2025, 9 a.m. How long has he been in?
He was in for a month before the violation and then got out, was picked up. He's been in for a week at
this point.
At this point, since he was picked up.
What do I have as bound on?
Or to be clear, he did report to community corrections when they told him to after the positive blows.
I think it was denied, Your Honor.
Yeah, I think his bond at this point is denied. Well, I'm not going to consider anything at this time, but what I will do is I'll set his pretrial and sentencing on the bond violation for the 17th. At that same time, I'll set his bond at this time at a $25,000 cash.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Matthew Bullard.
Ashley Feltus for the people.
Show cause off of that. They're not here. Matthew Bullard. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set at $5,000. I think 10% for which on that. That warrant will issue immediately. Court calls case of the people versus Dion Covington.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren, on behalf of Mr. Covington. Say your name for the record, please, sir.
Yeah, Covington.
Your Honor, regarding the underlying case, we have come to resolution. Mr. Siller has extended a plea of or offer of double parking on the possession of drug paraphernalia case. Mr. Covington is on probation on 14A2. There he was sentenced to 365. And his probation was revoked with a release to treatment. So once this case is resolved, the hope and the plan is that he'll be released to get assessed and get released to treat inpatient.
So it's double parking. Is that correct, Mr. Siller?
That's correct, Your Honor. So I move to add count 2 of double parking. And of course, if you accept that admission, move to dismiss the original charge.
All right. Mr. Covington, do you admit responsibility to the fact that on or about June 23rd, 2025, Carpenter Road, Pittsfield Township, that you double parked a motor vehicle?
Yes, sir.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost $180. That will be payable 90 days after release.
Honor.
Thank you. Case people versus Deanna Conrad.
Conrad Siller on behalf of Pittsfield Township.
The Assistant Public Defender, Natalie Tate, with and on behalf of Ms. Conrad, who is present via Zoom. Ma'am, can you please state your name for the court?
Deanna Conrad.
And also Ashley Feltus for the people, Your Honor. I believe there's a state case.
Case, there is. All right, what are we doing on this?
Your Honor, as to the case of public,
1880, this one is.
Your Honor, as to the case of the public defender is already on, which I believe is the case ending in 1088. I would be requesting an adjournment. Ms. Conrad is hoping to get her license, but does not yet have it. And then as to the arraignment on the other case, Your Honor, I would waive any formal reading. My client stands via, and I would ask for an adjourned pretrial date on that as well.
And ma'am, you do wish to be represented by an attorney?
Yes. Yes.
In the case 1880, defendant having waived formal reading, standing mute, court will enter a not guilty plea. I will also, well, I'll adjourn both cases to keep them together to the 17th, 2025 at 9 a.m.
Would Your Honor entertain possibly a longer adjournment given the one case is a licensed case? I don't believe she'll be licensed in 2 weeks.
Oh. I can do October 15th.
That would be excellent, Your Honor. Thank you very much. I apologize.
I'll adjourn both cases then to October 15th, 2025. Then as to the alcohol charge, what is the alleged BAC in this one?
0.255, Your Honor.
Any prior
No, Your Honor.
crash?
Yes, Your Honor. Single vehicle crash, Your Honor.
Single? Oh, my God. All right. Anything you want to, I'll set her bond at a $25,000 personal recognizance bond. Standard conditions including no assault behavior or possession of any weapons. In that case, ma'am, there is to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
I do.
I also will order that the defendant is to report over to the Department of Community Corrections for placement on a scram tether.
Your Honor, is she to do that within the next 24 hours?
Yes, she is to report within the next 24 hours.
October 15th.
All right. All right.
Thank you, Your Honor.
Thank you.
Thank you, Ms. Conrad.
Thank you.
Court calls case of People versus Benelli Cruz.
People.
All right, you are before the court on a misdemeanor complaint that alleges the offense of assault and or assault and battery that is alleged to have occurred on May 22nd, 2025, the Washington County Jail. You understand that charge, ma'am?
Yes.
That is alleged to have occurred against a Kyra Brown. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand the maximum penalty?
Yeah.
All right. Do you wish to be represented by an attorney, ma'am?
Yes.
It's a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Cruz. Good morning. We waive formal reading and stand mute to the charges, Your Honor.
Defendant every way formal reading. Standing mute, court will enter not guilty.
Next.
Okay, you've been in for a minute.
Yeah.
Seeking adjournment.
I am seeking adjournment, Your Honor. Miss Cruz will be in custody until at least next year. So she's been in for, I think, 383 days at this point.
All right. You want the 17th or the 15th of October?
We'll take the 17th if that's okay.
September 17th, 2025, 9 a.m. Her bond, she's in custody on a sentence. Is she under sentence?
Yes. I understand.
You know, set her bond at a $10,000, 10% bond. Order standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, drugs, and she is to have no contact with Kyra Brown.
Thank you.
Thank you.
Welcome.
Court does call the case People versus Catherine Cummins.
That's about some people.
Cummins. I'll issue an order to show cause. Court calls the case of the People versus Jay Dingman.
Conrad Solar on behalf of Pittsfield Township.
4 cases.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Dingman. Mr. Dingman, please state your name for the record.
Jay Dingman, Your Honor.
Your Honor, we are here in a pretrial. We have come to a resolution. I did, the court should have a plea form. I did just notice that the maximum penalty on the charge does say 90 days. Trespass is a 30-day, under the ordinance, 30-day misdemeanor, I believe.
That is correct. I would like to amend that to 30 days rather than 90 days.
30 days, is it 3250?
And or 100.
100.
Not only did I get the days wrong, I got the amount wrong too of the fine.
So 30 days.
And or 100.
$100.
Correct.
I just caught it too, and the reason I was checking is Mr. Dingman has been in custody for 40 days as of today.
He's been in custody already for 40
Yes.
on this case.
These 4 files, as well as a resisting and obstructing case that's before Your Honor, scheduled for the 11th for PCC.
Gotcha. So he's gonna plead to the trespassing charge. And then case ending in 1394 would be dismissed.
As well as cases 1366 and 1365.
All of these would be dismissed. And then this one, he's pleading to trespass. Got it. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Sir, it is this court's understanding that you're going to plead guilty to the charge of trespassing. That is a misdemeanor, punishable by up to 30 days incarceration, $100 fine plus court costs. Do you understand that?
I understand, Your Honor.
All right. Still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Hey, now you understand that by pleading guilty, you'll not have a trial of any kind.
I understand, Your Honor.
All right. You had signed an advice of rights form?
I believe I did, yeah.
Okay. Do you have any questions regarding those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal outright.
Yes, I do.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes.
October 1st, 2024, at the location of the Washington Food and Gas located at 4975 Washington Avenue in Pittsfield Township. Were you on those premises?
Yes.
Had you been ordered previously to not be on those premises by an agent of the owner of those premises?
Yes.
All right. I think it's going to be immediate sentence, so I'll just skip the rest of it. Counsel, have I complied with the court order? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to that charge. Cases ending in 1394, 1366, and 1365 are dismissed pursuant to that agreement. Anything you want to say before I do impose sentence?
No.
I think I have to. State minimums or state fee of the $125. I'm not sure I had to do that, but I will. And then 30 days jail, credit 30 served. Thank you.
Thank you, Your Honor.
Court calls the cases of People versus Chad Jones, 3 cases.
Conrad Solar on behalf of Pittsfield Township.
Lauren Perny on behalf of Mr. Jones. Your Honor, I had contact with Mr. Jones. There is a violation report.
Yes, I do see that. So,
I feel like they filed it in cases.
We'll issue bench warrants in these cases. Bench warrants, $5,000. Give a 10% privilege on all 3 cases. Those warrants will issue immediately. We have it.
Yep.
Okay, she can be released whenever. Court does call the case People versus Ashley Fix.
Conrad Solar on behalf of Pittsfield Township.
Public Defender Natalie Pate with and on behalf of Ms. Fix, who stands to my right. Please state your name for the record, ma'am.
Ashley Ann Fix.
Thank you, Your Honor. There is a resolution in this matter to which Mr. Siller would be adding a count 2 of double parking, and the misdemeanor charge would be dismissed.
That's correct, Your Honor. So I'd move to add count 2 of double parking. If you accept the admission, move to dismiss the original charge.
Ms. Fix, do you admit responsibility to the fact that on or about January 3rd, 2023, Ann Arbor Sling Road, Pittsfield Township, that you double parked the motor vehicle.
Yes.
Court will accept that admission to count two. Count one is dismissed. Fines and cost of $180. That will be payable 90 days after release.
Thank you, Your Honor.
All right, thank you. Court does call the case of People versus Tiara Peterson.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pay on behalf of Ms. Peterson on both matters. Ma'am, can you please unmute and state your name for the record?
Yes, Tyra Peterson.
And Ashley Feltus on the state matter, Your Honor.
All right.
Thank you, Your Honor. There is an offer in the case ending in 0918 that I do need to have a conversation with my client about. And I have briefly discussed this matter with the people as to the state case that I need to speak further with my client about what she would like to do. So I'm asking for a very brief adjournment.
Adjourn these matters to September 17th, 2025, 9 a.m.
Thank you, Your
Bond
Honor.
continue.
Thank you, Your Honor.
Thank you, Ms. Peterson.
Court does call the cases of the People versus Matthew Fonseca.
Conrad Solar on behalf of Pittsfield Township.
And Ashley Feltus for the people.
Lauren Perry on behalf of Mr. Fonseca. Mr. Fonseca, please state your name for the record.
Matthew Fonseca.
So, Your Honor, we've been adjourning for a global. Seems like we're very close. I think this may be our last request for an adjournment. Mr. Fonseca has circuit court on Thursday.
This Thursday.
The 4th.
Okay.
I think there's a resolution there that will kind of trickle down and resolve these files. So
Okay.
I think the 17th will work for us.
September 17th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Calls the cases of the People versus Matthew Wallace.
Conrad Solar on behalf of Pittsfield Township.
Ashley Feltus.
Good afternoon. Assistant Public Defender Lauren Perry on behalf of Mr. Wallace. Mr. Wallace, please state your name for the record. And I did speak with Mr. Wallace. We had a plan. I don't have an explanation for his failure.
How's that going?
Not well. He is enrolling in treatment. So hopefully it's gotten that ball rolling. I'll get in touch with them. I guess.
Okay. Hope you beat us to him. Bench warrants will issue. Bond will be set in the amount of $5,000, 10% in each case. Those warrants will issue immediately. Court does call the case of the People versus Brian Gerard.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Gerard. Mr. Gerard, please state your name for the record.
Brian Gerard.
Thank you.
Your Honor, we have come to a resolution. However, I'm going to ask for one adjournment. Mr. Gerard has a resolution up in circuit court that is close to being completed. I just want to make sure that this resolution is not going to hold whatever is going on up there.
That makes sense. September 17th, 2025, 9 a.m.
Thank you.
Thank you. Am I?
Yes.
What time are we?
It is 11:05.
Well, I can start calling some 11s if we gotta mess council up, but I'm gonna do it anyway.
Ready to go, Your Honor.
This one is ready, that's Mr. Campbell.
Court calls case of the People versus Shanice Greer.
Had a mission not to lie.
No, it's okay. I don't feel so bad.
Jake on behalf of Ms. Greer.
Your name?
Shanice Greer.
All right.
Judge,
Good morning.
Shanice is up in recovery court, Judge Kunkes. The question both Ms. Feltz and I have asked is if a misdemeanor can be transferred up to the recovery court, if the court would allow that. I need to talk with Ms. Sample. I would ask for a 2-week adjournment to find out if that's possible.
If which court would allow that?
Well, the recovery.
I'll send it.
Pardon me? No, I understand.
I'm
No, I would have really appreciate that. I have to find out if Ms. Sample will take a
If
miss.
they'll take the miss.
Yeah.
Okay. I'll adjourn this matter then until September 17th, 2025, 9 a.m.
Right. Thanks, Judge. Have a nice day.
All
Thank
right,
you.
thank you. Court calls cases of versus Vincent Lambert. 3 cases.
Conrad Solar on behalf of Pittsfield Township.
Lester. You have who?
I went to FCU.
You got Lester? I got it. I'll pass the Lambert matter. Court does call the cases of the people versus Paris Lester.
Conrad Solar on behalf of Pittsfield Township.
Lauren Kearney on behalf of Mr. Lester. Mr. Lester, state your name for the record.
Paris Alexander Lester.
Your Honor, we're asking for an adjournment of the pretrial, which I think we're gonna be able to resolve them, just working some stuff out. Really vague explanation.
Well, 17th work, enough time for you to
I think so,
try to
yes.
get everything done. All right. Adjourn these matters to September 17th, 2025, 9 a.m.
Thank you.
Here.
I lost.
Court does call the case of people versus Ranklin Dieg. Might be D. Dieg. What is that set for? Arraignment pre-trial, unless you in order to show cause on that case. Court does call the case of people versus Brandon Nash. 2 cases, or 1 case.
Good morning.
Good morning, Your Honor. My name is Melanie Calderon Lemus, and I'm a student attorney in the Civil Criminal Litigation Clinic at the University of Michigan Law School. I am requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Sarah Sallin, who is present here via Zoom. I'm representing Brandon Nash, who is also present via Zoom. Brandon, can you unmute yourself and state your name for the record?
Brandon Nash.
We're here for a pretrial.
For me to, are you gonna wait for me to answer your motion, or you're just gonna go? Yeah, I mean, no, I mean, if you wanna just go ahead, we can skip what I have to do.
Sorry, I'll wait.
Will you? Do you have a partner?
Yes, but he's in class right now, so he's not able to attend.
He's really not in class. He just
Yeah, I
sent you here.
believe
He got scared, didn't he?
Yeah, he got scared.
Okay. Young lady, where are you from?
I grew up in Las Vegas.
Oh, sorry. No, I'm kidding. Where'd you go to undergrad?
I went to Cornell in upstate New York.
Oh, excuse us. Okay. And now you're here at Michigan?
Yes, I love it here, much more than Cornell.
Okay. Cornell. That's some school up there. Okay. All right. Anyway, I won't say what I got to say. Permission to practice is granted. Welcome aboard.
And Ashley held this for the people you're on.
And Professor, welcome back.
Thank you, Judge. Happy to be back.
Okay. Okay. What are we doing on these?
So
Now you can talk.
thank you. So we just got added to the case last Thursday. So we'd like more time to confer with our client and more thoroughly review the discovery we've been provided and potentially conduct more investigations on our own. So we're asking for an adjournment.
All right. Will September 17th be enough time for you?
That works for me.
Okay, well, good. Glad to hear that. All right. I'll adjourn it to September 17th, 2025, 9 a.m. or as your invite indicates, bond in each of these matters will continue. All right.
Thank you.
Hold it. This other one, hang on a second, counsel. this one doesn't.
That appears to be an arraignment felony case they threw down.
Yes.
Ah,
Yes, Your Honor.
okay. So I've adjourned the misdemeanor case. He also, Mr. Nash also has a felony case.
Yes.
Mr. Nash?
Sir.
All right. Let me do this. I don't, where's my info? Okay. All right. I've got to arraign you on a felony charge. Okay. Mr. Nash?
Okay.
Your
I have a
Honor, just for the record, we're unable, I believe we only represent him in the misdemeanor. That's the restraints. So
Right, I think that's correct, and I think if he wants an attorney, it's gonna be a public defender case.
great. Thank you, Judge.
Oh, all right. So, sir, you are before the court on a felony complaint that alleges that on or about March 3rd, 2025, at the location of 3145 Ann Arbor Saline Road in Pittsfield Township, Washington County, State of Michigan, that being the Meyer store, that you did commit the offense of retail fraud in the first degree. Do you understand the nature of that charge, sir?
Yes, sir.
All right. That is a felony punishable by up to 5 years incarceration, a $10,000 fine plus court cost. The fine could be increased if 3 times the value of the property taken. If that's greater than $10,000, that would become the maximum penalty. You understand that, sir?
Yes, sir.
All right. First question I have for you, sir, is do you want to be represented by an attorney?
Yes, sir.
All right, this is a public defender case.
Good morning, Assistant Public Defender, representing on behalf of Mr. Nash. We waive formal reading and standing charges.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. I will set a probable cause conference in this case date.
September 18th.
18th.
Yes, sir.
I will set probable cause conference for September 18th, 2025, 9 a.m. as your invite would indicate. As to bond, you may. Let me ask you this.
Yes.
I realize they can't represent on the felony case. However, the court does take note that the charge that they do represent him on is also a retail fraud second. And so do you mind them? And so there may be some bearing on it. Do you mind if the clinic is part of the bench conference?
I do not mind, Your Honor. I think
Okay. Go ahead.
there's co-defendants in both cases. It's the same co-defendant. So my educated guess is they're appointed because the PD had to withdraw because they represent the same co-defendant in the mid.
So oh, gotcha. So the co-defendant is the same on both cases.
That's my understanding.
Okay.
Which means we would be appearing for arraignment purposes only and be withdrawing because we already have been appointed to the co-defendants cases.
Yes,
Okay. Is that what you wanted to approach about, or is
No.
there something, there's more?
there is more, Your Honor.
Oh, this is beautiful.
I'm so
All right. I'm gonna need Ms. Sullivan, student attorney, and myself into a breakout room. I'm gonna have to step off and
Mhm.
then do it that way. Doesn't matter.
Fun, exciting first hearing.
What?
Attorney.
What'd you say?
It's just fun for the first hearing for a student attorney.
Oh, yeah, she looks excited. She looks absolutely terrified. Like, what the heck is this about? That's what she looks like. Don't worry, you're not in trouble yet. What's your partner's name?
Sam Fisk.
Say again?
Sam Fisk.
Okay, so tell them they're in trouble
Okay,
because
yeah.
they're not here. You had to do all this heavy lifting, okay?
Yeah, I will.
All right. Okay, record should reflect, we've got a bench conference on this case. I will also adjourn this matter out to September 17th, 2025, 9 a.m. All right,
Your Honor.
thank you. Bond continue. Court calls case of the people versus Jason Holloway, or Holdaway. I think it actually is.
Ashley Feltus for the Peoples.
Yes, sir.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Holdaway. Mr. Holdaway, say your name if you hadn't already.
Jason Holdaway.
Okay.
Your Honor, we are asking for adjournment as we are in negotiations.
September 17th, 2025, 9 a.m. Bond continue. Thank you, sir.
Thank you.
Court does call the case of the people versus Alicia Kolowick.
Ashley Feltus for the People. Assistant Public Defender Natalie Pate working on behalf of Ms. Calloway, who should be present via Zoom. Ma'am, can you please unmute and state your name for the court?
Alicia Calloway.
I got Zoom user. She's gonna need to turn on camera.
Yeah, okay.
Hold on, I'm getting there. Okay.
Okay, got her. Okay.
Thank you, Your Honor. I am requesting an adjournment in this matter. I was able to review the discovery with Ms. Calloway. I need to have a further discussion with her regarding this, and she would also like to view her discovery on her own. Thank you, Your Honor.
September 17th, 2025, 9 a.m.
Thank you, Ms. Calloway. Thank you, Your Honor.
Court calls case people versus Theory Reynolds.
Folks for the
Conrad
People.
Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Reynolds. Mr. Reynolds, state your name for the record, please.
Reynolds Theory.
All right. I have a plea form that indicates that he'll be pleading to the charge of allowing an ineligible driver to operate.
That's correct, Your Honor, and it does have the correct maximum penalty on it.
Yes, the 90-day offense. Upon a successful plea to that charge, the driving while unlicensed would be dismissed. That's the court's full understanding of the agreement.
That is also our understanding, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes, sir.
State your name.
Theory Reynolds.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days in jail, $500, $100 fine plus court costs. You understand that?
Yes, sir, Your Honor.
All right. Still wish to plead guilty
Yes, sir, Your Honor.
to that charge? How do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir, Your Honor.
All right. You signed an advice of rights form. Is that correct?
Yes, sir, Your Honor.
Any question regarding any of those rights?
No, sir, Your Honor.
Look at paragraph 5. You'll see it on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, sir, Your
Are
Honor.
you on probation or parole?
Yes, sir, Your Honor.
Okay. Were you on probation or parole at the time of this offense?
No, sir, Your
All
Honor.
right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir, Your Honor.
Anybody threaten you or coerce you?
No, sir, Your
You're
Honor.
doing this voluntarily
Yes, sir.
of your own free will
Yes, sir, Your Honor.
and because you believe that you're indeed guilty of this offense?
Yes, sir, Your Honor.
April 9th, 2025, at the location of Washington Avenue in Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes, sir, Your Honor.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes, sir, Your Honor.
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Sir, anything you want to say before I impose sentence?
I take full accountability for my actions, and moving forward, I learn to make better decisions.
I will say on behalf of Mr. Reynolds, Your Honor, he's been in custody for 27 days as of today. He has a number of cases in 14A2 that are scheduled for the 11th. He does not foresee getting out on the 11th. He's asking for a credit for time served sentence. He is in a bit of a financially difficult time for his family.
Fines and costs of $250. That's due and payable 90 days after release. I'll also order 90 days in jail credit, 27 balance suspended. So he's done on my case of it. Fines and costs at some point. All right. Thank you.
Thank you, Your Honor.
Thank you.
Court does call the case People versus Mia Holly.
Votes for the people. Public Defender Natalie Pate with an on behalf of Ms. Holly, who should be present via Zoom. Ma'am, can you please unmute and state your name for the court?
Need to unmute.
I'm sorry, can you hear me?
Yes, we can hear you. State your name.
Mia Holly.
Thank you, Your Honor. I have discussed both of these matters with my client, and I did propose a potential resolution to the people last week. I would be requesting an adjournment to further negotiate with them.
September 17, 2025, 9 a.m. on both matters.
Thank you.
Thank you.
Thank you, Ms. Holly.
Thank
Court
you.
calls case People. You're welcome. Court calls case People versus Gregory Sistron.
Feltes for the people.
Good afternoon, Public Defender Lauren Perny on behalf of Mr. Sistron. Approach the podium, please state your name, sir.
Gregory Sistron.
Thank you.
We're asking to set this for final settlement, please.
Jury, final settlement conference, October 17, 2025, 9 a.m. Jury selection, October 20th, 2025, at 8:30. Both of those proceedings are in person. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls case of People versus Kevin Castle.
Public Defender Natalie Pate on behalf of Mr. Castle, who may be present via Zoom. Sir, if you'd like to please unmute and state your name for the court. Feltes for the people.
Not checked in.
Thank you. I do not have an explanation for his failure to appear. I did send him a text. I attempted to call him, but his voicemail box is not set up yet. Beyond that, I don't have an explanation. Would ask for an adjournment for the record.
Bench warrant will issue for defendant's failure to appear. Bond 5,000, 10%. That warrant will issue immediately. Court calls case of the People versus Lerone Kelsey.
Feltes for the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Kelsey.
Hello.
Hello, I need a camera.
Here, sir.
All right, state your name.
Lerone Larry Kelsey.
Thank you.
We are requesting an adjournment. If the court may remember, Mr. Kelsey is is going to the military. We're waiting on some documentation from his recruiter so I can get that over to the people and hopefully resolve it.
September or October?
You think you can get me that information by the 17th, Mr. Kelsey?
Yes. 17. Yes.
Then I'd ask for that date, Your Honor.
September 17th, 2025, 9 a.m. All right. Thank you, young man.
Thank you, Your Honor.
Court calls case of the People versus Kevin Smith.
Conrad Solar on behalf of Pittsfield Township.
And Public Defender Natalie Pate with and on behalf of Mr. Kevin Smith, who is approaching the podium. Please state your name for the record, sir.
Kevin Smith.
Thank you.
Thank you, Your Honor. There is a civil infraction resolution in this matter in which Mr. Siller offered added count 2 of double parking in which count 1 would be dismissed. I did discuss that with Mr. Smith and he would like to accept that today.
That's correct, Your Honor. So I'd move to add count 2 of double parking. And of course, if you accept admission, move to dismiss the original charge.
Sir, do you admit responsibility to the fact that on July 2nd, 2025, at the Washtenaw County Jail at 221 Hogback Road, Pittsfield Township, you double parked a motor vehicle?
Yes.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. Those will be due 90 days after release.
What'd she say? What'd you say?
Due 90 days after release.
All right. Thank you.
Thank you, Your Honor.
Court does call the case People versus Debbie and Julia Martinez.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate for Ms. Martinez. Your Honor, it's my understanding, or I was informed that she is refusing to come up today. I will state for the record, however, I did meet with her on Monday down at the jail, and that visit went well. She advised me that she did put her name on the list to try to get started in jail Dawn Farm. So I guess I would request an adjournment of this case, or this pre-trial.
September 17, 2025, 9 a.m.
Thank you, Your Honor. Thank you, Your Honor.
Court calls case People versus Shannon Kiesling.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Kiesling. Ms. Kiesling, state your name for the record, please.
Shannon Kiesling.
Okay.
Yeah, we're requesting an adjournment
Of
there.
course you are. Now go ahead.
Well, there is a potentially a subsequent case that Ms. Feltus is looking into. I think there's a warrant request.
Got it.
Yeah.
Adjourn it to September 17, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Okay, thank you.
So.
Yeah.
So, court calls case People versus Jessica Yoder.
Asphalt for the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Yoder. Ms. Yoder, please state your name.
Jessica Yoder.
You know, we're requesting an adjournment. Miss Lonnie and I are in negotiations.
Is this, how many more cases does she have? Is this it?
In front of Your Honor, she just has this. Well, she has a PCC scheduled for the 11th. I guess just this.
That's
just this.
September 17, 2025, 9 a.m. Bond continued.
Thank you.
All right, thank you. Is that it for you guys back there? Thank you. Okay. Court calls case People versus Lindsay Kohler. Arraignment.
This is a show cause you're feeling too.
Got it. She's not operating well in Touchfield. Alleged BAC on this matter.
.16 with active THC.
Bench warrant will issue for the defendant's failure to appear. Bond is set in the amount of $15,000, 10%. That warrant will issue immediately. Court calls case People versus Noman Khan.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Khan, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Noman Rahman Khan.
Thank you, Your Honor. I am requesting an adjournment of this case. Mr. Khan has been very responsive to me. However, we need to schedule a time to actually go through all the discovery together.
September 17, 2025, 9 a.m. Bond continued.
Your Honor. Thank you, Mr. Khan.
Thank you.
Court calls case People versus Shamira McKay.
National Police People.
Well, what's your name?
Shamira McKay.
All right, Ms. McKay. You are here on a show cause, but you're here on a misdemeanor complaint that alleges that on or about December 27, 2024, at the location of 2307 Twin Lakes Drive, apartment 1B in Pittsfield Township, Washtenaw County, state of Michigan, that you did commit the offense of child abuse in the 4th degree. Do you understand what you're charged with, ma'am?
Yes, I do.
All right. That is a misdemeanor punishable by up to 1 year or probation up to 5 years. You understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
That's my dad. Yes.
What did Dad say?
You think so, Dad? I guess so, yes.
Yes. It's a public defender case. Anytime. No.
Assistant Public Defender Natalie Pate with and on behalf of Miss. Last name is cool. McKay. I'm sorry, Your Honor.
It's okay.
Assistant Public Defender Natalie Pate with and on behalf of Ms. McKay, would we waive any further reading of the complaint? My client stands mute and asks that a not guilty plea be entered. We would also request an adjourned pretrial date, please.
And then having waived formal reading, standing mute, court will enter a not guilty plea Pretrial in this matter will be adjourned September 17th, 2025, 9 a.m. Or as your invite indicates. Mr. Bond in this case.
Yeah, the people are requesting no contact with Jane Miro Wright, who is the child victim in the case. The spelling of the name is on the bond information form. I can give it to your report right now. That's
It's on bond information.
It is.
Anyway,
Interesting. I know. Well, maybe I did.
well, that's
Put it on that side now. Any objection to the no contact?
yes.
Your Honor, my client does advise me that that is her 16-year-old daughter, so I would be asking for consensual contact with her.
Is there a way that I can approach him? Because see, all this is un-
Does,
because of this. Yeah.
does she?
Yeah, she's never been removed from my care. CPS has closed out the thing and she's in therapy and everything. Not once has she been removed from my care.
Does she reside with her?
Absolutely, Your Honor.
Well, ma'am,
Yet,
ma'am, you got an attorney. She resides with her. Okay.
At the time, my report's from December of 2024, and at the time they did have the same address, Your Honor. I am still requesting no contact.
Your Honor, if I may, my client advises me that the complaining witness has been residing with my client since this incident date and does currently stay with her. My client represents to me as well the CPS case arising from this incident has since been closed as well.
Exactly, and she's never been removed from her care. Say that.
Bond is setting amount of $10,000 personal cognizance, loader standard conditions, including no assault behavior, possession of any weapons. You understand that, ma'am?
Yes.
I'm going to order also no alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes.
I will order that with reference to contact. I'm going to do it this way. No non-consensual contact. Going to be with Jamira Wright. And what that means, ma'am, is that if she doesn't want to have contact with you, then you can't have contact with her. Okay. I'm not sure what arrangements you've got family, what arrangements would have to be made if, but for some reason she just says, I don't want to have contact with you. I would suggest to you at that point that maybe she goes stay with somebody else until such time as you can get back here, we can get that straight. Okay. I'll do it that way. All right. Rather than straight no contact. All right. Anything else?
Nothing, Your Honor, except a dumb question. It was the 17th, correct? Is the next court date?
Yes.
Thank you, Your Honor. Other than that, nothing else. Thank you.
Thank you. Thank you. Court does call the case of the people versus Anthony Miller.
Votes for the people. Good afternoon, Assistant Public Defender on behalf of Mr. Miller. Your Honor, I have not had contact with Mr. Miller. I did contact him multiple times.
Are both on or just one? Bench warrant will issue for defendant's failure to appear.
I'll let the court know that he did fail to appear in a PCC very recently as well.
Yes, I do. And bond in this case will be setting him at $10,000. I'll give a 10% privilege, notwithstanding his failure to appear.
Thank you.
Warrant will issue immediately. Let's call the case of People versus Kenneth Miller.
Ashley Feltus for the people.
Good afternoon, this is the Public Defender Lauren Perry on behalf of Mr. Miller.
Kenneth Miller.
Your name, sir?
Kenneth Miller.
Thank you.
I am requesting adjournment as we are in plea negotiations.
September 17th, 2025, 9 a.m. Bond continued. Thank you, sir. Court calls case of the People versus Charles Mosley.
Ashley Feltus for the people. Show cause for agreement.
Charles Mosley. No response. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. So I'll give a 10% privilege on that. That warrant will issue immediately. Court calls case of People versus Abigail New.
Ashley Feltus for the people.
Assistant Public Defender Natalie Page, is present via Zoom. Ms. New, could you please unmute, turn on your camera and state your name for the court?
Oh, there she is.
Abigail New.
All right, thank you.
Thank you, Your Honor. I believe this is a case that is going to be resolved, and I have had a lengthy discussion with my client regarding the discovery. I need to follow up on one thing on my end, as well as likely another discussion with my client. I'm requesting an adjournment.
And that's correct, Your Honor. I do believe we've reached a HIDA resolution here, but we still need to get the plea form done. It sounds like there's a couple other things to do. It's my fault the plea form's not done today. But
It's okay. September 17th, 2025, 9 a.m. All right. Thank you, ma'am.
Thank you.
Court calls case of the People versus Jason Olson.
Ashley Feltus for the people.
Olson. Issue an order to show cause. Failure to appear. Court does call the case People versus Donnie Brown.
Conrad Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Brown approaching. Ms. Brown, please state your name for the record.
Reverend Donnie Brown.
Thank you. All right.
We're asking for an adjournment. Ms. Brown has some tickets that I'm gonna assist her in trying to resolve.
Quite a few of them are.
It's one, sir.
I'll give her some time to do it. October 15th, 2025, 9 a.m.
Thank you.
All right. Thank you, ma'am.
Okay.
Court calls case People versus Esther Chinula.
Conrad Solar on behalf of Pittsfield Township.
Public Defender Natalie Pate with and on behalf of Ms. Chinula, who should be present via Zoom. Ma'am, can you please unmute and state your name for the court?
Chinula. Not present.
I do not have an explanation for her failure to appear. I believe she's appeared for all the court dates, and I did just yesterday. We're going to ask for an adjournment for her to take the road test again. She unfortunately told me that she did not pass. We're supposed to take it next week. I would ask for an adjournment for the record. I did expect her to be here today.
Bench warrant will issue bond 5,000, 10%. Court.
Always a parallel parking.
That's it. Court calls the case People versus John Collins.
Conrad Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Collins.
Yes.
All right, Mr. Collins, I need a camera. Oh, there you are. Okay. What are we doing?
So I do not have any contact information for Mr. Collins. So I was unable to speak with him. Mr. Collins, what I'd ask you to do is call the public defender's office and update your contact information.
I gave that to them in the last court hearing. And that's the only number I have.
Let's try it again. Maybe it didn't make its way into the file for some reason.
What am I holding on for?
A phone number. 734-35.
No, not your phone number. Let me give you a phone number to call.
Oh, okay, I'm sorry. All right, I'm ready.
734
Okay.
222
Okay.
6970.
6970. Can I read that back to you to make sure it's right?
Sure.
734-222-6970.
You got it. Call them and make sure they have a good phone number for you.
All right.
All right. Thank you. We'll see you on the 17th.
On the 17th?
Yes.
At what time?
I adjourned your hearing out to September 17th.
What time?
Well, I'm going to set it at 9, but you'll get your time block from your attorney.
All right, thank you.
Thank you. Court calls the case of People versus D'Amico County.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Cummings. Mr. Cummings, can you state your name for the record?
Yeah, I'm trying to turn my camera on.
Put the high people.
Yeah.
D'Amico Cummings for the record.
Your Honor, we are requesting an adjournment.
Again? What, you have more tickets clear up or what?
Nah, I just take care of a lot, but I had it's another case I got. They told me to by October it's my last adjournment with them, and I was just like, hey, I could do that by then. So, and I know it's suspending my license, not like exactly. So I'm about to just it's only like a few $100s.
Okay, never mind. October 15th, 2025, 9 a.m. Court calls case People versus Keith Dyer.
Conrad Siller on behalf of Pittsfield Township.
This is an arraignment and retrial without counsel.
Keith Dyer. Issue an order to show cause.
Oh, you know what, Your Honor? I'm going to dismiss this case. There's no township.
Even better.
There's no township ordinance for insurance.
Okay.
So
Case is dismissed. Court calls case People versus Marcus Earl.
Conrad Siller on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Patelin on behalf of Mr. Earl, who I believe is present via Zoom with his mother. Mr. Earl, could you please state your name for the court?
You need to unmute. Marcus Earl.
Marcus Earl.
All right.
Thank you, Your Honor. I'm requesting an adjournment.
Is Mr. Earl present? That's his mother.
What I would like to ask the court is you find him guilty of driving without a driver's license and just fine him.
Ma'am, you can't ask me to do that for him.
He's incoherent and mental ill with paranoid, schizophrenic, and I don't know any other way.
Ma'am, you're gonna have to talk to the attorney of record on the case. I can't just do that on your word.
Okay. And what is the number? I'll ask Natalie if you could send me that attorney's number so I can contact them, because he's incoherent and very mentally ill.
I got it, ma'am. So
okay.
If I may, very briefly, Your Honor, I did speak with Miss Earl yesterday and her son was present. It is my understanding that she then called downtown to speak with me this morning. However, of course, I was in court, could not speak. I do need to have another conversation both with Miss Earl as well as Mr. Earl. That being said, I'm requesting it.
September 17th, 2025, 9 a.m. Thank you.
Okay, thank you. And Natalie, if you could give me a call, or I'll call you to talk about it and talk to Marcus. Thank you.
Yes, I'll call again tomorrow.
Okay, bye.
People versus Imlandani Esolela.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Esolela. state your name for the record, please?
My name is Mr. Montania Solela.
Your Honor, I was wondering if you could tell us whether his license is valid. Unclear to me at this time.
No,
Okay, well, then I'd ask for an adjournment.
it's revoked. There's a 625G permit. I don't know if you know that or not.
Well, the complicating factor is he says he's gone to Secretary of State and they said this case is holding him up, which that is not my understanding of, they said he has to resolve
His
this
status,
for,
his driver's, it's revoked, 625G permit.
okay,
I'll let you try to sort it out. I'll adjourn it to October 15, 2025, 9 AM.
thank you. Okay,